That brings us to another topic of bail and bond. This is another topic. This is another topic. This topic, a lecturer will take with you 2 weeks. I've summarized it in 2 minutes. So I think you can know the difference. Bail and bond. So at the stage of bail and bond, therefore, what is bail? And what are the types of bail that we have? So bail is in form of money. Money that you pay, money paid to secure release of an accused. Remember now the word accused is coming in. You are an accused now because you are now in court. Accused of committing an offense. Of an accused. But the rationale of bail and bond is so that an accused can attend court. So money paid to secure release of an accused to attend court. Therefore, we come to types of bail. Number one, when you are arrested, the police should always think of the first thing to give you a bail. That type of bail is called a police bail. But because hapa Kenya polisi wengine ni wazuri lakini wengine bore sana, shenzi sana. Call police bail. So some will give you, some will not give you. Because they always say power from above. If you go to above, there's another above. And if you reach that above also says power from above. So I don't know if it is. Anyway, police bail. Number two type of bail is the bail that you ask for in court. When you are in court, it is called bail pending trial. Bail pending trial. Number three type of bail, after you finish that trial process and you lose a case, you are convicted or you are acquitted, you can choose to appeal or the DPP can choose to appeal. That is called bail pending appeal. Number four, you can win that case in the appeal court or lose it. Then you decide that you want to appeal it or the prosecution appeals the conviction or the sentencing or even on a ruling. That appeal is called bail pending second appeal. You are making a second appeal. Then there's another fifth one, which we call the anticipatory bail. Anticipatory bail. You anticipate that we'll be arresting. This is called bail pending arrest. For example, after teaching here, Ruto can decide to send his thugs or rogues to come and arrest me here tomorrow. Then I rush to court. I take anticipatory bail that you should not arrest me. You need to tell me of the reason why you want to arrest me. Because nowadays it's not even arrest, they are abductions. That bail is called bail pending arrest. After being granted, you can the court can decide to tell you to go to the police station to get to know why they wanted to arrest you. But they will not arrest you because there's a bail that you have called an anticipatory bail. At that particular moment, we also talk about bond. Bond is a security in form of a collateral. Collateral. Security in form of a collateral. that the court will have, that you issue to the court to secure your freedom. Collateral that an accused produces in court to secure his or her freedom so long as they will attend court, or he or she will attend court. This collateral, the collaterals are in form of a pay slip, can be a pay slip, can be a logbook, and can also be a title deed. The next is now we discuss the types of bond. Number one is police bond. At the police station, you can be given a bail or a bond. So police bond. Number two is personal bond. Personal bond is where the court tells you that, Babu, we trust you. We know you, we trust you. Just go, or you stand in for yourself. Personal bond. Number three, another type of bond that we have is called bond and surety. Surety. Now, bond and surety, that brings us to this word called surety. Surety is a person, is in form of a person, a living thing, mtu, who has a relationship, a person with a relationship. Person who has a relationship with an accused person. Can be close relationship. To stand in for the accused person. If you fail, if an accused person fails to attend court, that surety, you will be held liable. You will be arrested, you will be called to court, you'll be arrested, you can be arrested, and you will be charged. So, is everything okay? Hey, wacha ni kunywe hata chai. Oh, sorry, maji. Class, tunaendelea, tuko sawa? Lazima mpite orals na exams. Thank you. Then, the court should automatically grant you bail or bond, or both. The court can grant you bail or bond, or both. Then the prosecution, saa zingine wanakuwa watiaji sana, wanasema we don't want Babu to be released on bail or bond. Therefore, they must convince the court beyond reasonable doubt that there are compelling reasons, and I urge you to read the bail and bond policy class, that there are compelling reasons, and they want to tell court that because of these compelling reasons, we cannot release an accused person to be out on bail or bond. Number one compelling reason, they always say that an accused person is a flight risk. That if we release him on bail, huyu mtu atapotea, hatawahi kuja kotini, and they must prove that utapotea. For example, if you are a Nigerian citizen in Kenya and you've been arrested for committing an offense in Kenya, and they know that you can run away, then they may opt to prosecute you, to finish the trial process while you are in prison so that you don't go back to your country. That is flight risk, that there's a possibility of you running away. But again, that can be cured by the fact that you can be ordered, the court can order you to deposit your passport in court so that you can't take ndege, not unless unataka kuswim to Nigeria. You can't take ndege without that. Number two reason is that you can interfere interfere with witnesses. That you can interfere with witnesses. And this is very possible. You know, one of the candidates of ICC interfered with all witnesses. In fact, interfered and disappeared with witnesses. The main suspect of ICC. Sijui kwa nini alikuwa anatuita criminals, but it's okay. That you can interfere with witnesses. And in the interference with the witnesses, you can also argue that, you know what, you have witness protection. Chukua witnesses, wafungie huko kwa witness protection. Number 3, that antecedents. This can mean that you had been admitted to bail in another case before, you jumped that bail, you did not attend court, and therefore the court is convinced that if you are given another bail in another case, then therefore you will not attend. So antecedents. So the court may deny you on that ground. Number 4, there's what we call the habitual offender. Habitual offender. That, you know, this person has been committing crimes. Amekomiti, tulimwacha, akakomiti, tukamwacha. So this person is a nuisance in the eyes of the DPP. But again, you can rebut that by saying that every case must be treated with its own facts and merits. The fact that I committed an offense before and I've committed an offense now, allegedly, because it has not been proven, then you should not admit me on bail. Why? And this, I will bring you and take you back to your second year LLB. When you are doing your degree, you did the law of evidence. And you did a case of John Mackin versus the Attorney General, the case that was prosecuted in the United Kingdom under the doctrine of contemporaneous similar fact evidence. Dispensing knowledge carelessly. Eh? Can you? Eh? Now, the case of contemporaneous similar fact evidence. John and Sarah Mackin was a husband and wife. They used to kill children in a bathtub, takes them, then buries them in the yard. Wanaenda kotini, wameshikwa, wanaenda kotini, charged, found culpable. Again, wakishatoka prison, they kill another child in a bathtub. Remember, there's a sequence I'm following here. A bathtub, bury in a yard outside their house. Now, there is a day that another person killed a child in a bathtub and buried in the yard. Same way, the police did not ask any question. The police did not get the suspect, but the police went to arrest John Mackin and Sarah, the wife. Then upon the arrest, the High Court found them guilty, culpable. But upon appeal, the appeal court let them free and said that the fact that these people have been killing in a bathtub and burying in the same way in the yard does not mean that they are the ones who killed that other child in a bathtub and buried in the yard in the same way. Contemporaneous similar fact evidence. So this one can be rebutted by the fact that every case should be treated with its own facts and merits differently. Then number 5, we talk about own safety, for your own personal security. Personal security. That if we release him on bail or bond, this person is going to be killed. For example, if an accused person commits an offense and the members of the public are looking for this person to lynch him, then he will not be released because he's going to be killed. Number 6, if an accused person is a threat to the national security. This means most cases that falls here, and by the way, it was also in my own case, and they were saying the other day when I was arrested last year, when they disappeared with me and took me to Kirinyaga. They abducted me and took me to Kirinyaga. Imagine the prosecutor was saying that I'm a threat to the national security with all the tools of violence that they have. I'm still a threat to the national security. Anyway, tutakutana mbele. But most cases that they use here are cases of terrorism. So those are some of the compelling reasons, among others, that you may also know